You're sitting at a red light on South Colorado Boulevard when a driver plows into the rear end of your car at 40 miles an hour. Your neck is already stiffening from the violent crash. The other driver gets out and immediately says, "Don't worry, Colorado's a no-fault state. Your own insurance takes care of this," and takes off. You think, well, okay, if that's how it works. So you call your own insurance company, they open a claim, pay for some medical bills, and close the file in 3 weeks. You just left thousands of dollars on the table because of a myth. Here's what the other driver did not tell you. Colorado is not a no-fault state. It used to be. Colorado had a no-fault system for decades, but that ended in 2003. Since then, Colorado has been an at-fault or tort state, and the difference between believing that myth and knowing the truth can be worth tens of thousands of dollars in your case. The phrase no-fault sounds simple. Every state is either a no-fault or tort state, right? The reality is more complicated. And that confusion is costing Colorado accident victims real money every single year. In a true no-fault state, the law requires every driver to carry what is called personal injury protection, or PIP coverage. When you get into an accident in one of those states, your own insurance pays your medical bills and lost wages first, regardless of who caused the crash. Fault does not matter for that initial PIP claim. The whole point of those systems is to get injured people paid faster by cutting out the adversarial back and forth with the other driver's insurance company. Colorado does not work that way. Colorado's an at-fault state, also called a tort state. That means the driver who caused the accident is responsible for your damages. Their insurance pays your medical bills, your lost wages, your pain and suffering, not your insurance company. But the at-fault driver's insurance company does not pay until you've reached a settlement or gone to trial. If another driver rear-ended you and put you in the hospital, you go after their liability coverage, not your own policy. But in Colorado, you have to figure out how to get your medical bills and lost income covered until that settlement or judgment comes through. In no-fault states, your own insurer controls the claim from the start. In Colorado, you have the right to make a claim directly against the at-fault driver. That means you can demand full compensation for every category of loss: medical expenses, future treatment, lost income, pain and suffering, and more. The at-fault driver's insurance policy is what you are pursuing in Colorado. So where does this no-fault confusion come from? There are two main sources. The first is medical payments coverage, also known as Medpay. Colorado law does not require you to carry Medpay, but insurance companies must offer it and other drivers buy it as an add-on to their policy. Medpay pays your medical bills regardless of fault. It does not matter who caused the crash. Your own insurer pays those bills, usually somewhere between $5,000 and $25,000, depending upon how much Medpay coverage you bought. Victims who experience Medpay kicking in after an accident may conclude incorrectly that Colorado must be a no-fault state because their own insurance company paid some medical bills. Medpay is one optional coverage. It's not the system. Your right to go after the at-fault driver's insurance exists completely independent of Medpay. The second source of confusion is how insurance adjusters talk. When you call to make a claim against the other driver's coverage, adjusters sometimes speak in ways that make it sound like they're not going to pay for anything. They're not lying, exactly, but they're not explaining the full picture. Because in Colorado, they typically don't pay until your damages are able to be calculated. They won't tell you how to get the medical care that you need to document and recover from your injuries, and they won't tell you how to cope with lost wages. They typically only focus on getting your car repaired or replaced. That's because the at-fault driver's insurer has a financial interest in your bodily injury claim being worth as little as possible. They're not there to help you, only to protect the driver that caused the crash and pay as little as possible. Letting you believe they're not obligated to pay anything after you make your claim, or that you are limited to your own coverage, is one of the easiest ways to make that happen. If someone leads you to believe Colorado's a no-fault state, they're either confused or they want you to be. Understanding that Colorado is an at-fault state matters because it defines what you're entitled to pursue. In a true no-fault state, your ability to sue an at-fault driver for all of your damages is often limited. You can only cross into the civil claim system after your injuries pass a certain threshold. Colorado has no such restriction. If another driver's negligence injured you, you can pursue a full claim for all of your damages. There's no threshold that you have to cross before you can hold the other driver's party responsible. Colorado's minimum insurance requirements are $25,000 per person and $50,000 per accident for bodily injury, and $15,000 for property damage. Those minimums exist because Colorado's system places responsibility on the at-fault driver. If the driver who hit you only carries no coverage or only minimum coverage and your damages exceed that, You then look to your own uninsured and underinsured motorist coverage, which is something Colorado law requires insurers to offer every policyholder. You can decline that coverage in writing, but if you have it, it fills the gap when the at-fault driver cannot. So this is the structure of your rights as a Colorado accident victim. Your own insurance company is not the first company in charge of your recovery and compensation. The at-fault driver's insurer pays for your damages, but won't pay for them as they're incurred. Your underinsured motorist coverage backstops you when theirs is not enough. Medpay can help pay for medical bills, but it's not the system. Insurance companies are not charities. Their job is to resolve claims for as little as possible. The no-fault myth serves that goal perfectly. If you mistakenly believe Colorado is a no-fault state, approach your own insurer hat in hand, accept some Medpay, and do nothing else, the at-fault driver's insurer never gets a real demand. This pattern plays out in a predictable way. A victim is hurt in a crash, someone mentions no fault, and the victim thinks their own policy is the ceiling. They may get some sporadic treatment with their Medpay coverage, but by the time they call our office, their case is broken beyond repair. Maybe evidence regarding who was really at fault has been lost, or timely medical evidence regarding their injuries or linking those injuries to the crash is lacking. The at-fault driver may have an insurance policy with limits of $100,000 or more. Your Medpay coverage might be $5,000. If you settle the Medpay claim without understanding you have a separate right to pursue full compensation for all of your damages against the at-fault driver, you may be walking away from most of what your case is worth. Before you sign anything, before you give a recorded statement, before you accept a payment and think you're done, know what state you're in and what system governs your claim. In Colorado, the at-fault driver owes you. Make sure that is who you are actually pursuing. There is another part of Colorado law that most people have never heard of, and it works against you in a way that will surprise you if you're even partially at fault for what happened. Here's where Colorado law has a twist that catches a lot of people off guard. Colorado uses a system called modified comparative negligence. Under this system, your compensation is reduced by whatever percentage of fault is assigned to you. If you're found 20% at fault for the accident and your total damages are $100,000, you recover $80,000. That part is familiar and makes sense to most people. But here's the part that matters most, the 50% bar. If you're found to be 50% or more at fault for the accident, you recover nothing. Not reduced, zero. Colorado draws a hard line at 50%. Cross it and your claim disappears entirely. This is exactly why understanding Colorado's no-fault system creates such a problem. If you go through your own insurance, accept what is provided through your Medpay coverage, and never understand that you had a right to pursue the at-fault driver, you may never know that a full comparative negligence analysis would have placed most of the fault on them, not you, and could have resulted in you getting your damages compensated by the other driver's insurance company. And on the other side, if an insurer is trying to push your fault percentage up toward that 50% threshold, knowing what they're doing and why is the only way to fight it effectively. I have a full video on how comparative negligence works in Colorado and what you can recover even if you were partly at fault. Watch that one after this if you want the deep dive. That is the natural follow-up. If you need to talk through your situation now, Mintz Law Firm is available 7 days a week for a free consultation. The number's in the description, and drop a comment below. Did you already know Colorado was a no-fault state? Or did the no-fault myth have you fooled?